Hello, my name is Chris Roberts. I'm an attorney in St. Louis, Missouri. And today I want to talk about something in the legal profession that we've been talking about the last couple of days, not only in the legal profession, but all of us in the United States, and that is the unfortunate passing of Justice Ruth Bader Ginsburg. Justice Ginsburg was an incredible person. She was a champion of human rights. She was a champion of women's rights, civil rights, and even bigger than that, a champion of the underdog. She's also known for her powerful dissents. So today I want to talk about a powerful dissent that has affected me in my practice, and it's probably a dissent that you haven't heard of. And it was from a dissent in a case that she was part of last year called Lamps Plus versus Varela. And the dissent deals with the issue of consumer arbitration, or sometimes what we refer to as forced arbitration. Let me give you a little bit of context of what this means. Typically, if we have a grievance with a business or an employer, and we can't resolve that grievance, we can file a case in a court of law, and we can have a judge or a jury decide who's right and who's wrong. In these arbitration agreements, however, that strips people, employees and consumers, of those rights. Rather, what the arbitration agreement says is you cannot file a case in court. You have to file the case in arbitration, and also you can't file the case as a class action. You have to file it individually. So think for a second. Let's say that you've been aggrieved by a business, and maybe you've been shortchanged $100 or $200. That case individually may not be worth pursuing, but if the same business shortchanged hundreds or thousands of people $100 or $200, the case makes sense to pursue, and also that type of a case can effectuate change for a larger group of people rather than one single person. So what these agreements do is they say not only do you have to arbitrate the case, but you can't arbitrate it as a class. You can only arbitrate your individual $100 or $200 claim. And this is where Justice Ginsburg comes in. She has long been a champion of the consumer and the employee in the context of recognizing that these forced arbitration provisions were not really what's called the Federal Arbitration Act was intended for. What she says in her dissent in the Lamps Plus versus Varela case is that the Federal Arbitration Act, which requires arbitration of certain disputes, was originally designed for people of equal bargaining position. In other words, commercial disputes. So business to business, not business and consumer or business and employee. With that context, she issued a very powerful dissent. And the facts of this case were as follows. An individual who worked for a company had his personal information hacked because of presumably the company's negligence. It wasn't only him, it was 1,300 other people that had their personal information compromised. In fact, the individual that filed the suit had a fraudulent tax return filed because of this compromise. So what he did is, to help himself and these 1,300 other people, is he filed a class action lawsuit. And the company said, no, you can't file a class action case. You have to file this in arbitration. And by the way, you can't file this as a class action in arbitration. You can only file it as an individual case in arbitration. Trial court said, we agree the case should be arbitrated, but you can arbitrate the case as a class. Supreme Court disagreed. What the Supreme Court said is that the case could be arbitrated, but only as an individual case, even though the agreement did not affirmatively state or prohibit the parties from arbitrating that case as a class action. What Justice Ginsburg said in her dissent was very powerful. What she said is, by adopting this position, that there's a couple things that happen. One is you have effectively stripped people of their access to vindicate their rights, particularly where a class action is necessary because these claims are so small that an individual will not pursue them. She notes that the alternative, or in other words, the status quo, means that nobody is going to vindicate their rights. And the reason nobody is going to vindicate their rights is because nobody has the resources to file a case that's worth $100 or $200 or maybe even $500 when the cost of doing that greatly exceeds the value of the claim. So what Justice Ginsburg says is that essentially, by doing this, you've left the employees in the case between a rock and a hard place. You've said either accept our arbitration agreement or don't work here or quit your job. And she says that's not right. But what she does at the end of her dissent is what I think is the most powerful thing. She calls on Congress to make a change. And the reason she does that is because she is disturbed by the court's jurisprudence that's not giving consumers and employees any recourse. It's allowing the business to strip consumers and employees of their right to pursue cases in court and their right to pursue these cases as class actions. The reason I think that is important is this. We have seen over time that Justice Ginsburg has made a similar appeal, and that similar appeal has worked. So back in the early 2000s, Justice Ginsburg dissented in a case involving a woman named Lilly Ledbetter that dealt with equal pay. And what she said is Congress needs to act. The courts are not giving women recourse. They're not giving them equal protection. Congress needs to act. And what happened was, after she issued that dissent, Congress did act, and they passed the Lilly Ledbetter Act, which provided more equality in terms of pay for women. My personal view is that not only was Justice Ginsburg a great justice, but her dissents are incredibly powerful. A great dissent is one that, while it's not in the majority at the time of the opinion, it becomes law over time. People begin to recognize what the dissentant is saying, and that what they're saying is, in fact, the proper way to go in the long run. And hopefully, Justice Ginsburg dissent of just last year can make a similar change in terms of consumer arbitration. I appreciate Justice Ginsburg's dedication on the bench. I appreciate her dedication to women's rights, human rights, civil rights, and for being a champion of the underdog. Rest in peace. Thanks for listening.